Good morning. Welcome to our presentation on COT software licensing and end user license agreement best practices. In the DoD Enterprise Software Initiative, we've been focusing a lot on training the workforce on these best practices, and we hope that you find it worthwhile and informative this morning. I am Floyd Gross. I work for the Department of Navy CIO, and I co-chair the DoD ESI working group. It's the support of the ESI team that's pulled a lot of these best practices together, and I have with me one of our subject matter experts who supports the DoD ESI. Before I turn it over to Tom, we will take questions during the presentation, so feel free to ask questions during the presentation. Tom?
Thanks, Floyd. And we do have a person in the audience who has a microphone, so if you have a question, please raise your hand and she'll bring you the mic. So as Floyd said, what we're going to cover today is a fair amount of material that has to do with some of the key clauses that you might encounter in any end-user license agreement for software. In particular, our focus is more on enterprise software, the larger, more complex packages, but many of the things we'll talk about this morning can be applied virtually to any end-user license agreement or EULA. The way that ESI approaches the topic is to segment the key clauses into 5 groups. As you can see on this slide, we have license grant, pricing, warranty, maintenance, and general provisions. And then, as this slide indicates, there are subtopics under each of those 5 major topics. In this case, for license grant, there are 12. Rest assured, the rest of them don't have as many, and we're going to fly through this material. My apologies in advance if we're going pretty fast, but again, as Floyd said, if you have questions, please raise your hand and we'll be happy to do our best to answer them. So beginning with license grant, we start at a very basic point, and that is to define the parties to the agreement. You would be surprised how many end-user license agreements are somewhat vague and ambiguous about exactly who it is we're contracting with. And the other thing to know, in addition to specifying exactly who the parties are, what their names are, the organizational names, that is, the addresses, and some description about whether they're a publisher, a reseller, or have some other status, it is important to note whether we're dealing with the publisher of the software, the company that wrote it and owns the intellectual property, or whether we're dealing with a reseller of that software who represents the publisher in the marketplace. And as we all know, in the government, you're often dealing with that reseller. And a little bit further in the presentation, we'll talk about why that is so important to understand and what some of the implications might be of dealing with a reseller instead of the publisher. The next section under the license grant has to do with requirements. Now we're getting into what could become a pretty heavy topic. And this is requirements not just in the market research part or phase of the procurement cycle where you're trying to figure out what is the best product, but it's also the requirements that you might need to articulate in the end user license agreement. And we'll touch on this point several times throughout the presentation to talk about why that's important. In my experience in the commercial world, this is where a lot of projects or a lot of sales go off the tracks, is that the customer has one set of expectations about what they think the software can do, and the company who publishes the software or resells it has a different set of expectations. And so we often see lots of angst and controversy, and people get upset about those things. And what the message is here from ESI is that if you think requirements need to be documented, they should be documented in the end-user license agreement thoroughly to avoid those conflicts. Now, if you're licensing something like Microsoft Office, you probably don't need to worry about specifying the requirements because most people know what it does. It's well tested in the marketplace, and there's no need to go into a lot of details. But if you're about to license something like SAP or Oracle's ERP suites, or something maybe a little less cumbersome but equally complex, you should probably think about how those requirements should be documented. And we have a couple of very simple examples in the presentation. One that's at a pretty high level that ties your requirements somewhat to the product names, which also have to be carefully listed and specified in the end user license agreement. But in addition to just listing the product names, we recommend that you also list the business processes that you plan to execute with the software and tie them to those product names, so that there is some notice on the part of the vendor that your expectation is that these modules and submodules, as you see listed on the right-hand part of the slide, are able to execute your processes that are listed on the left-hand part of the slide. And we also like to put that little proviso that's at the bottom of this slide that says, and oh, by the way, vendor, if there's anything else that you're aware of that we need to execute these business processes, whether it's your product or some third-party product, we would appreciate it if you would let us know, because we've experienced in the government several instances of finding out later, after the initial license is purchased, that other software is necessary to do the things we want to do. And again, this all goes to the importance of documenting those requirements that you have as thoroughly as possible. Now, on this slide, we get to another level of detail below the prior one, where ESI recommends that you may consider what I think is a commercial best practice, and you may want to use it in the government if it fits, and that is to list your requirements, for example, in column A, along with a granular level of detail about what the steps and the processes are. This, I realize, is a big, big task, very time-consuming, but it can avoid a lot of controversy down the road if you do this. And then what we want to do in column C in this example is to list the vendor's response, whether it's in your RFI, your solicitation, whatever other document or mechanism you might use to solicit these responses. You should record them and make them a part of the end user license agreement. And there are three choices that the vendor has. The vendor can say, yes, I meet your requirement as documented, as I understand it. No, I can't meet that requirement. Or they might say, I'm able to do something like what I think you're saying, and let me explain to you how it is that I do it, so that we're both on the same page about that requirement. And you can see in this case, the example of an answer other than yes or no is the requirement to print checks in the financial system. And believe it or not, some software packages in their financial systems are not able to print checks out of the box. And this vendor said, you know, we can't print out of the box, but we do have a custom subroutine available that can help you to print checks. So that would be an example of where your requirement is not met 100%, but the vendor is able to do something. If you go through this process, you could potentially avoid a lot of upset and discontent later down the road. And in the commercial world, what we used to spend a lot of time doing in the companies I worked in is to answer these questions and then to demonstrate to you with the software how it meets your specific requirements. So again, we establish that we're both on the same page. And what I'm hearing now in the industry and in the government is that some people, some buyers or prospective buyers of software licenses are actually recording, video recording, the demonstrations that are done by vendors and making those videos part of the end user license agreement. It's not a bad idea in a significant purchase of complex software to consider doing something like that and getting, obviously, the permission of the vendor to record them. The next part of license grant has to do with the duration of the license, and there are two basic choices here. We either license software perpetually into perpetuity, meaning forever. Doesn't mean that the software is supported by the vendor forever, but you have the right to use it forever. Or you can buy a license to use software for a specific term or period of time. And the word subscription is here because usually when a customer buys a license for a term, like 1 year, 3 years, 5, whatever the case is, you might pay for that license as you go on a subscription basis similar to a magazine, as opposed to one big lump sum up front, as is done usually with perpetual licenses. Because we teach this a lot in class, I'm just tempted to say, are there any questions? Because if you have any, please don't be shy. We're happy to answer them. The next part of the license grant is permitted uses. And again, this is a potential area of problems if we don't handle it appropriately. And what you see on the slide is that we might consider listing the things that we're allowed to do with the software by the life cycle of the procurement process. This is just one approach you might consider. So in the selection phase, we just need trial and demo permission. In the implementation phase, now we need development and test. And then in the operational phase, we need the full scope of authorized use, including backup and recovery and COOP, which in the government, I believe, stands for continuous operations. Something that happened, that came up, I believe, after 9/11. What I like to do as an attorney and as someone who's drafted a lot of commercial software licenses and negotiated them, is that I like to make this as broad and ambiguous as possible, this particular clause. I think the broader it is, the less likely you are to fence yourself in and to forget something. So a little statement that says something like, the government has the right to use this software for all lawful purposes necessary to the fulfillment of our mission. Very broad. Vendors will hate it, but it gives you a lot of latitude in what you're able to do. And lawful covers the fact that you will not misappropriate their IP, and the purposes of your mission does confine your use somewhat. Again, my concern is if you begin to list the things you can do, you may forget something that could be very important ultimately. And it also encourages the vendor to list the things that you can't do. So we have a yes and a no list, and I personally just don't like them. Next is authorized users. Who is authorized in our organization to use the software? This is not the number of users. This is just the category. Which types of users are permitted? And again, I think the broader the better here. All users authorized by the government to use this software to fulfill our mission is one way to approach it. But if you have to get down to listing categories, just obviously try to make sure you don't forget the contractors or the military personnel or the foreign nationals in the field. Depends on where the software is going to end up as to who those authorized users might need to be. Next is geography. Where can I use the software? For the life of me, I can't understand why anyone would sign a license where the use geographically is limited to anything less than global. Even if you never think you're going to use it outside of Washington, D.C., there is no reason to buy a license for software that is so restricted. So you should always say global. The only time a vendor has a legitimate beef about the scope of geography is if their support organization is not capable of providing follow-the-sun 24/7 support, and you might need to have to pay them in order for them to establish that capability if it really is a legitimate need on your part. Some vendors will try to convince you that a restricted use or a limited use license is cheaper. I would ask them why. Why? What is it about your license other than you just decided to charge me more money for a global license than for a DC license? What is the rationale? Again, the only rationale that I can think of is if they don't have support around the world where you would be using the software. Next is language. You probably just need English, but you should specify American English. You want to make sure that the training, the documentation, all the things that are necessary to operate the software, the support people, all are fluent in American English. And if you need other languages, you should specify. These days, most software comes in multiple languages. When I first started in the industry with SAP, it was a big deal. They had 7 languages, and that was a big deal back in those days, but no longer. So again, you should take the time to list the languages in your license. Sticking still with license grant, the next thing is how many copies of the software am I permitted to have? Usually a commercial vendor's license will say you can have 1 copy. That probably is not sufficient. Just think about if you've ever participated in a major software implementation, how many copies of that software you might need. You probably need something for your sandbox, as we used to call it, where you set up and configure the business processes. You would need another copy for your test environment, for your quality environment, and ultimately for your production environment. So at least 4 or 5, maybe more copies of the software might be required. You may want to make a golden disk master and then distribute it somehow that way. Whatever it is that you think you need, you should put it in the end user license agreement so that you're not stuck with just 1 copy of the software. The next area under license grant has to do with audit. As you probably know, software vendors like to come around periodically and check to see if you are in compliance with their license in 2 ways. With respect to the quantity that you licensed, whether it's named users or otherwise, and we'll get into that later in this presentation, the various ways of counting, and whether you're in compliance with respect to the uses that are authorized, as you saw a few slides ago. And you want to make sure that you stay in compliance. But what you don't want is an open-ended right on the part of the vendor to come in at any time, even with notice, and to audit your use, go into your systems, go into your facilities, and use third-party software tools that are designed to discover or find out what is in your system. You don't want that to happen. So what ESI recommends is that you have a clause in your end-user license agreement that says that the government will self-audit, that we will keep meticulous records of the number of users and the uses that are permitted, and if you want to do an audit, we'll provide you with that report with adequate notice, as opposed to allowing a third party in.
Yeah. Now, we know that getting companies to agree to self-audit can be very difficult. In some cases, the contracting team is very successful, and others not so much. But what it does is trigger that conversation and does get the right types of discussions going to improve the audit language in any end-user license agreement, making sure that we know how they're going to audit, other confidentiality requirements so that information doesn't get shared, those kinds of things. So it's really important just to trigger that conversation.
Absolutely. The next clause or the next part of the license grant has to do with something known as times of conflict. And this is something that arose as a result of 9/11.
Yeah, what we found after 9/11 is we needed to quickly reestablish network operation centers that were destroyed. So we developed an ESI language that we call times of conflict or temporary expeditionary deployment that vendors are willing to sign up for within certain boundaries that will allow us to react to national emergencies and address the licensing issues at a certain point, but it doesn't restrict us from establishing the information technology capabilities that are needed in those environments.
Now, this is a complex slide on a very complex topic that we could spend the rest of our time together talking about, and I'll try to do it in just a very short period of time. There are 2 topics really that we're talking about on this slide having to do with ownership and use rights as part of the license grant. And the first one is pretty simple and straightforward that we can put aside very quickly, and that is the ownership of the data. The government, obviously, or any customer for that matter, but the government always owns its data regardless of where it sits, whether it's at rest, in transit, on your premises, under your custody and control with a third party, no matter where it is, you own it. And you should say so in your end user license agreement. And you should say that you have the right to demand your data with reasonable notice, usually 30 days, in the format that you require it. And you should also add, because sometimes vendors will act a little bit poorly, and they might destroy your data after 30 days if you don't pick it up. So you want to make sure that you tell them in advance in the agreement that's not permitted. The other topic that's on this slide, as I said, is a really big, complex topic, and it has to do with what's called derivative works. Has anybody out here heard of derivative works in licenses software? You have, okay. So you know how complicated that topic can be. And what this slide is trying to show is that on the left-hand side, we're dealing with commercial off-the-shelf software, COTS, which is the thrust of this presentation. It's commercial software that is produced and owned by a publisher. They have proprietary rights in it, and they license the use of it. On the right-hand side of the slide, we're talking about custom software where you might hire someone to build software to your specifications for your use. In that case, you should always take ownership of the underlying intellectual property that is created, as well as an executable version of the software. So you need to make sure in those custom agreements that you do that. But in the more common commercial COTS software agreements, the fact is that if anything is created in the use of that software that might be considered to be a derivative work, guess who owns it? The publisher. The publisher owns all derivative works. Now the question is, what constitutes a derivative work? And we could spend a lot of time discussing what that might look like, and it's a very gray area in the law, frankly. So what I prefer to do is to focus on how do I deal with derivative works if they come up, as opposed to trying to define them to the nth degree. And there are really two basic choices to make. Number one, do I need to own the derivative works that might get created? And think about what the possibilities are here. I have one story for you that I heard from one of our colleagues who worked for the Army for over 30 years. And in the course of her work with the Army licensed some gaming technology that they used as a platform to build battlefield tactics to teach our troops how to fight against our enemies. And the gaming company took a look at what was created and said, this is really cool stuff. I want to put this in our product and license it to all the kids of America. And the Army, of course, said, no, I don't think so. But the problem was that the end user license agreement did not call out who owns derivative works. And so on that legal front, the gaming company had a pretty strong argument. But of course, the Army ended up winning on a confidentiality basis. The point is, you don't want to find yourself in that situation. If you think you need to own a derivative work, you should say so in the license agreement. It might cost you more money, but it's going to be worth it. The other choice, the second choice, is to say, you know, I don't need to own it, but what I do want is a worldwide, perpetual, royalty-free license to use the derivative work. Because again, you have to recognize that that piece of code belongs to the publisher, not to the government, even if you pay somebody to create it, even if a third party creates it. The analogy I like to use is a book. Let's say that I write a book and Floyd wants to make a movie out of it and writes a screenplay and produces a movie. We all know that in order for him to do that, he has to talk to me first, he has to sign a contract, and he has to pay me a lot of money, especially if the book is called Jaws or something. So you're not going to allow the same thing to happen, or you must allow the same thing to happen in software, because the software publisher owns that intellectual property. All derivative works belong to that publisher. So you may be happy with just a hybrid situation where you just have a license to use it and you don't need to own it. So while we're on IP, we're going to talk about 2 or 3 topics here before we get to the pricing section, the second major segment of an end-user license agreement. And the first one is IP. We've already talked about it just a little bit, but at a very high level, there are 4 basic ways to protect intellectual property in the law: patents, trademarks, copyrights, and trade secrets. And you can see on the slide some examples of each and what they are. In the software world, companies usually don't patent anything. If they do patent something, they'll patent an algorithm, some sort of unique mathematics that they created to calculate a result of some sort. But what software vendors do is they copyright their software, because software is very much like a book or a piece of music or a piece of art, things that are amenable to copyright. Also, I think copyright is actually stronger than patent in one respect at least, and that is its duration. Copyrights are good for the life of the author plus 75 years, whereas patents are usually only good for about 17 to 20 years. So again, every vendor of software, virtually every vendor, has a copyright on their software. So that's the legal protection that they have. But we all know that there are a lot of bad people out there who don't care about what the law says, and they still might want to take intellectual property and try to sell it as their own property. So software vendors have a physical approach to protect their IP, and that is by taking the source code, which is the way the software is originally written by the developers in software language, but that language is human readable. Someone who understands the language can read it, decipher it, reverse engineer it, and create a product from it. So they convert that source code to object code, which is only machine readable and is not easily reverse engineered. And you can see on the right-hand side some samples of source code and object code. So although I don't know this particular language that well, I would certainly be able to sit here and read import.javax.servlet.http and so on. And so to someone who understands that code, it's very easy to figure out what the software is doing. But if it's converted to the binary or the binary opened in terminal or some other form of object code, we really can't understand exactly what that code is designed to do. So two protections, legal and physical. When you license the software, you get a copy of the object code, not the source code. And in our two-day class on this topic, we talk a little bit about a situation where you might need to escrow source code so that if the company goes out of business or refuses to support you, you can go and retrieve that source code and support the software yourself. Next is the issue of privity, another legalism but very important to contract law, and in particular, it has significance in the government arena. As I said earlier when we talked about defining the parties, you probably are dealing mostly with resellers of software representing the publishers. And therefore, your contract is with the reseller, not with the publisher. So privity says that if I want to enforce a contractual promise against someone, I need to be in the contract with that party. Makes sense. For once in the law, that kind of makes sense. So that means that if you're looking to promises that you might want to try to enforce against the publisher, if you have no contract with them, you may not be able to enforce those promises. And why is that important to us? It's important to us because of all the things listed at the bottom of this slide. Keep in mind, again, the publisher is the owner of the intellectual property, not the reseller. Only the publisher can promise to give you a license grant, to allow you to transfer licenses, to put their software into escrow, and all the other things listed here. Warranty in particular we're going to talk about in a few minutes. And something that's listed here, you may not understand what I mean by this, but level 3 support. So if the software has a defect or malfunctions and it needs to be fixed, and it ultimately can only be fixed by the developers who wrote the code in the first place, that is an obligation on the part of the publisher. If the publisher is not willing to do that and you have no privity with them, you might have a problem enforcing that expectation on your part that they would fix the problem. Go ahead.
Now, one best practice that we think is very important to implement when you're doing an enterprise license is to first work with the software publisher. Really get an understanding, get the agreement on those terms and conditions with the publisher. We also recommend that you get signature of a corporate official on that master license agreement, as we would call it, with that software publisher, and signed also by your contracting officer to get that enforcement mechanism for those things that really cannot be agreed to by a reseller or the party that you're contracting with as the prime.
Exactly. And again, one of the backup positions to consider is that if you can't get the publisher to sign the agreement or co-sign it with the reseller, you might ask for a copy of the agreement, the reseller agreement that exists between the publisher and the reseller. Because in that agreement between those two parties, the publisher has told the reseller what the publisher is willing to let them do in any end-user license agreement. In fact, most reseller agreements that I've seen actually have a copy of the preferred end-user license agreement embedded in it. So if you're able to obtain a copy of that, it's a really strong piece of evidence that the publisher was willing to extend the terms that are in that agreement. Another issue that we run into, and this is becoming a bigger and bigger issue every day, and that is the issue of what we call third-party software. So if you're licensing software, you can rest assured that in that software, the chances are almost 100% that there is some open source software in that product. There may also be some other third-party proprietary software in that product. So what this slide is trying to show are the two different scenarios that we might face. One is where we license software, and then we're licensing proprietary software separately, and we're licensing open source software separately. We know we're getting that software. We have a license agreement to back it up. There's no question about that. But the right-hand diagram indicates the area where we have a potential problem, and that is if the open source or the proprietary software is embedded and you don't know that. There's no way for you to know it unless you ask or the vendor tells you that open source or third-party proprietary is there. And I'm assuming everybody understands what open source software is. Just as a quick refresher, one-liner, we talked a minute ago about IP, where a company creates software and they want to sell it for a profit, sell licenses to it for a profit. Open source, and by the way, they protect the source code and only give you the object code. Open source is, as the name indicates, making the source code open to the public so you can see it. You can do anything you want to with it. And it's ubiquitous. It's out there on the internet. You can pull down pieces of code and put it in your product, and it happens every day. So what ESI recommends is that you cover these 5 points in a clause in your license grant. And that is that the vendor discloses to you all third-party software that's in their product. They will kick and scream and not want to do this. But your response is, I have a right to know what I'm buying. I need to know what's in your product, because I might have some vulnerability or potential liability to those third parties if you don't tell me what's in your product. And that brings us to number 2, that the publisher of the software you're licensing has obtained all the rights necessary to incorporate that third-party software into their product, meaning they've signed licenses and paid money, or they've signed a GPL, the general public license, to the open source community to use the open source. Next, that publisher should indemnify the government against any potential liability for licenses or fees to those third parties. Fourth, that publisher should warrant that the third-party software will operate the way they intended it to with their product. You'll get major, major pushback on this. In fact, I've seen several licenses in the government where a publisher will say, we may, by some chance, have third-party software in our product. And if we do, if you discover that it's there and it breaks, your recourse is with the publisher of that software. Well, we've already covered one topic here that would raise a red flag right away, and that's the privity topic. That third-party publisher doesn't know you from Adam. They have no way of saying, yes, I will support you, or no, I won't. You have no contract with them. So it's really incumbent upon the publisher that you're dealing with to back up the product they've put in their product. It was their decision, not yours. They should bear the risk, not the government, that that product will work or not work. And then last but not least, one of the downsides of open source is that if you enhance it, you have to share all enhancements with the open source community. Obviously, in the government, that could be a problem. We already talked about the Army gaming technology example. If you modify open source, either knowingly or unknowingly, in your software that you've licensed, you may owe that enhancement back to the public at large. So you want to get the publisher to promise that that won't happen, which is kind of a weak promise, to be honest with you. But the other thing you can ask them is the open source encapsulated? And what that means is that it's essentially wrapped up insulated from the rest of the software so you can't easily get to it and mistakenly change it. Okay, now we're going to move to pricing. Everybody ready for a new topic? I am. So we have 5 subtopics in pricing. The first thing that I would like to get across to you is that we should think about software like anything else that we buy, that it's an investment of sorts. And we might even want, in fact, in the commercial world, every customer does a return on investment, and we might want to consider doing that in the government to figure out whether we're getting our money's worth if that's not already standard practice. So with respect to the license itself, it's an investment in better information, better processes, et cetera. And you might ask yourself the question, is the price that I'm paying based on some perceived value of that software? Or is it based on market forces that this company has to charge what everybody else is charging? Or are they basing their price on their cost to develop the software or some other basis? So we need to understand it's an investment, and we need to understand how they came up with their price. With respect to maintenance and support, that to me is an investment in the future integrity of the product and your ability to get enhancements and fixes to the product. And maintenance and support, as we know, is usually expressed as a percentage of the net license fee that you pay. And then last but not least, in training and other services, that to me is an investment in people, to make sure that the folks who are using the software are able to give the benefits or get the benefits that were anticipated with the license. Now, big topic again, how do we count? Counting users. Big problem sometimes. And we're just going to express 5 simple ways here. There are others that you may encounter, but these are the 5 principal ways that we've seen commercial companies price their products. First is named user. So you count the number of people, the number of user IDs that will log into the system. You have 1,000 people in the organization. They all need to touch the software. So you buy 1,000 seats, as a lot of people refer to it. There was another pricing mechanism that used to be more popular than it is today, and that's known as concurrent users. So let's say you have 1,000 people in your organization, but only 100 of them use the software on a regular basis, and everybody else is more or less a casual user. So you might say, well, at any point in time, maybe 150 or 200 people are on the system. So you buy licenses to suit those concurrent users, how many people are on at one time. Then in more technically oriented software, or even in business application software, sometimes we count processors or cores to figure out what the price is. So it's so many dollars per processor. What also came into vogue back in the 90s when I first started at SAP was something called a site license. The rationale behind a site license was we don't know how many users might be at a particular location. And let's say we're a global manufacturing company and we have 100 plants around the world. We may want to license the software by site, by plant, by corporate headquarters, what have you. And the population might go up and down over time, so we don't want to be bothered with counting people. I think in the government, the stories that I've heard indicate that this has been taken to an extreme in some cases, and we've gotten ourselves in trouble because sometimes site licenses have been down to like a particular building on a particular facility. One of our colleagues also expresses a site license that was purchased for Building 283 in Fort Monmouth, New Jersey. So what happened when Fort Monmouth was bracked? Building 283 was no longer used. That license, without transferability, couldn't be used anywhere else. Enterprise licenses are similar. They're sort of like site licenses on steroids in a sense, because an entity, an organization could simply license unlimited use for their entire enterprise. Now, some people think that that means you never have to count again. Other people might argue that at some point you have to give a ballpark, either upfront or at the end of the license. Point is that enterprise licenses can work well, but you need to define the enterprise carefully. And
one more thing, communicate that definition of enterprise, what's in the scope. We've seen audits end up where we've had to pay additional dollars because the interpretation of enterprise, it was misunderstood by the buying organization, and the enterprise grew beyond the scope. So just a note of caution.
Right. I won't go into detail here on this slide. There's another slide later that I think depicts the structure of the cloud or SaaS in a little better format. But this one is designed to show you that cloud pricing has many elements to it: infrastructure, platform, application, lots of different moving parts. And we don't have time to go into all the details of how this pricing works. But just a caution, you need to understand the components of a cloud or SaaS offering and whether you're really saving money. One of the key questions to ask is, what is the time horizon that the vendor used to estimate or to calculate their SaaS price versus their perpetual price? Because if they used a 4-year horizon to amortize the cost and make all their money, and you plan to use the software for 8 years, you will literally pay double for that software versus the perpetual fee. So be aware of how the pricing is constructed. Another area of interest in pricing is discounting. Software is probably the highest discounted product on the face of the earth, at least as far as I know. I mean, you can get up to 95% discount. I can't think of another product where that happens. And by the way, that's also where site and enterprise licenses sort of evolved from, is that software companies recognized if they took their list price, for example, in the early days at SAP when I first joined, it was $4,000 a seat. If you licensed 100,000 seats, that's a lot of money. That's, what is that, $4 million, I guess. So you don't want to have to pay those exorbitant fees, and software companies didn't want to discount up to 95% and have the word get around on that. So they created this fiction of an enterprise or a site, and you sort of mask the number so nobody else can figure out how the pricing was done. But the point is that these discounts can get very steep, and don't be shy about asking for them because you're entitled to them. As the price goes up, the discount goes up.
And always understand the timing of when you're asking for pricing. You're going to get probably much better discounts or pricing if you're approaching the end of a software publisher's fiscal year. So just be aware of what's happening in the marketplace as well.
Yes. Another aspect of pricing in the commercial world is something known as TCO, or total cost of ownership. And we think of it in 3 parts: the requirements and the fit of the software to your requirements, because the lower the percentage of fit, the more expensive it's going to be for you to fill the gaps, and it's going to be more expensive to maintain those one-offs or those customizations. So the higher the fit, the better, the lower the total cost of ownership. The price itself, of course, is a major component, but then there is the aspect of the terms and conditions in the license that can drive up the price. If you ask for transferability, if you ask for self-audit, if you ask for a bigger warranty, there are a whole host of things that you might need, that you might want to ask for if you need to own derivative works. All of those things can drive up the price by virtue of those terms and conditions. I'm not going to read all the ones on this slide. You can see what's there as some of the examples of where discounting and pricing can be somewhat negotiable. And please make sure that you look at all 3 aspects of this. In the government, I think you refer to it as life cycle cost. In the commercial world, it's TCO.
And understand virtualization requirements. That's another term or condition that's important. Costs can go up dramatically if you haven't negotiated the right virtualization language in your end user license agreement, and you implement your virtualization in ways that are favorable to a price increase for the publisher.
Right. Another key element is benchmarking. It's always a good thing to know what other people have paid for the same product you're buying. In today's world, you go out to buy a house, you can find out very easily what other people have paid for the similar house in the same neighborhood. You go to buy a car, you go on True Cars or Edmunds or Kelly, and you can find out what you should be able to buy a car for, how much money it should cost. Same thing with software. There are benchmarking elements out there, and Floyd actually has something going on in the government you'll be interested in.
So first of all, the acquisition gateway is providing access to a prices paid portal that's being developed by GSA in support of OMB. In DoD ESI, we've been capturing purchase price information for 13, 14 years now, and so we developed a price history database that we're now starting to use to kind of at least provide price bands, trends in historical pricing that's used by our cost analysis centers as their baselining costs for major programs, as well as how we would provide information to customers who are wanting to know, I've got a requirement of this size, what could I expect in negotiating with this particular software publisher with this volume of new license purchase.
Can save you a lot of money. Okay, next, warranty, another deep topic. And again, I want to preface my comments here by saying that if you're licensing Microsoft Office, you probably don't need to worry about asking for a different warranty. The standard warranty of it starts when I deliver the product and it lasts for 90 days is probably okay for you. But if you're licensing something much more complex than that, you might want to consider whether the warranty that is provided out of the box by the vendor is sufficient to meet your needs. And there are 4 basic topics in warranty. What is covered, who is covered, when does it start, and for how long does it go, and then what are the remedies available. So I'm going to try to dissect this slide for you very, very quickly. We're talking here about performance warranties, how the product performs, not about other warranties like intellectual property and so on. And there are 2 basic types of warranty, implied warranties and expressed warranties. And within the world of implied warranties, there are 2 flavors of those, the implied warranty of merchantability and the implied warranty of fitness for a particular purpose. The analogy I like to use to drive this one home is going out to buy a washing machine, something we've all probably done at some point. If we go out to buy a washing machine, we go in the store, we self-serve, we find one we like, we take it home, we plug it in. Our expectation is that it will wash clothes. That is the implied warranty of merchantability. If I'm a merchant in the business of selling products, those products need to conform to a certain expected standard of performance that all people would expect to see. Now, if I go into the same store and I talk to a salesperson and I say, I'm going to open a laundromat, I need washing machines that will wash clothes of 50 pounds or more, it's going to run 24/7 or maybe 24/6, et cetera, and the salesperson directs you to a machine, now we're treading into the area of an implied warranty for fitness for a particular purpose. We've described the purpose, the merchant has told us, yes, it will meet that purpose, and away we go. The good news is that both of these are mentioned in FAR 52212-40. The bad news is that the entire commercial world is allowed to disclaim implied warranties, probably because they're too broad, too vague, hold the seller to a level of standard that is way above what they want to be held to. And so in lieu of that, they can't just say no warranty. What they say is, I'll give you an express warranty, meaning I'll write down what it is that I'm willing to cover. We've all seen that when we bought a car, what it is that's covered and what's not covered. With respect to software, the standard language usually is, my software will conform to my documentation. That's the statement of the publisher. That doesn't help us a great deal if we have a big set of complex requirements, because now we'd have to sit down and compare our requirements to their documentation to determine whether it in fact meets our requirements. The preferred approach is to say, vendor, publisher, reseller, I want you to warrant that your product will meet my specs. Now, hearken back to the slides we talked about hours ago, it seems like, that we talked about at the beginning of the presentation when we said it could be important to document our requirements. Well, this is where you tie that together with a nice little bow to say those requirements that are up front in our end user license agreement, that's what I want you to warrant. Big, big deal, hard to do. I recognize the issue. There are revenue recognition issues for the vendor, all kinds of things they're going to push back on. But if you think you need that warranty because you're spending millions of dollars, tens of millions, maybe even hundreds of millions of dollars on software, You want to make sure that it does what you think it's going to do. Again, we talk about who's covered. I'm going to just gloss over this because it's pretty straightforward. The reseller has no right to extend that warranty out of the box unless you have proof that the publisher said they could. This is something you want to get from the publisher. Most resellers won't even entertain the discussion. The timing of the warranty. If it's big, complex software, is it going to be good enough if it expires after 90 days? Probably not. The main purpose of the warranty is to give you, the buyer, a reasonable opportunity to discover defects. If you don't have that reasonable opportunity to discover defects, the warranty fails of its purpose. And by the way, you've already paid for it because it's embedded in the price of the software. Vendors know how often their product will fail. They know what their frequency of warranty fixes are and how much money they're going to spend, quote unquote, on their nickel, which is actually your nickel because you've paid for it. So the point is you may want that warranty to start later and last longer than delivery in 90 days, and you may want to tie it to first productive use or acceptance of the software. You need to have a way to report the defects, you need to know who's going to fix them, and you might want to suspend the warranty period while they're being fixed. You want to make sure that there's no additional charge for fixing warranty items, and you also want to specify the conditions under which you can get a full refund and return the product. The customer's view is, give me a product that works. That's the nutshell version of this. The vendor's view is, yeah, I want the product to work too because my reputation is at stake, but I need to limit my liability. It can't be open-ended forever, and it can't be things that are out of my control. So the tactics that vendors use to limit that exposure are listed here on the right. I'm just going to cover the first one, the integration clause. Sometimes it's referred to as the four corners of the agreement clause. Sometimes it's called the entire agreement clause. And basically what it says is that only what's written in my contract is enforceable. If I made a verbal promise, if I showed you a demo, if it's in a brochure, if it's on my website, sorry, doesn't count. It's only what's on the paper that matters, that you can hold me accountable for. So the moral of the story is, if you want a stronger warranty, you had better write it down and you had better tie it to your documented requirements. We hear a lot in the government contracting world about commercial items. And software vendors are famous for saying, you're licensing a commercial item, you need to take my commercial terms. While that may be true on the surface, there's a little bit more to the story. Number one, FAR Part 12 says, you still have a duty to do what's in the best interest of the government. Their standard warranty may not be in the best interest of the government. Number two, in the commercial world, warranties are negotiated all the time. So it is standard commercial practice to negotiate. When they say this is my standard term, take it or leave it, not true. And third, last but not least, there's something called the DoD Warranty Guide that says that warranty is as important as price and negotiation is encouraged. So don't accept the line, this is a commercial item, just take it or leave it the way it is. And ultimately what an expanded warranty comes down to, with almost anything in a contract, is a risk analysis, balancing the risks. Am I better taking the risks or should I transfer them to the vendor? And here are a list of factors to consider. What's the reliability of the software? What's the reputation of the vendor? And so on. But the one that I think is the most important probably is the cost. What is the vendor going to charge me for a stronger warranty versus how much would I have to pay to fix a problem on my own, and who would I hire to do it? How much would it cost?
And we encourage our contracting officers to really document the negotiations to show this warranty discussion. It really is a risk management issue, a risk analysis. And so having the file documented and having it presented as part of the total negotiation package to get approval to sign any contract is important.
Did you want to mention the risk assessment?
And yeah, we are working in ESI on what we're calling a risk assessment tool that will be providing a way of assessing the risks, in quotes, of signing up to the standard provisions of the end user license agreement that the software publisher first presents to you. that gives you an idea of where are the risks if we would sign up to this, all the different potential areas that we should, in fact, try to negotiate to bring it closer to our preferred or our best practices terms.
So the fourth of the 5 major segments of the EULA is maintenance. And again, we realize this is a really big topic that can take a lot of time. And we just have a few minutes to conclude our presentation. So we're going to go through maintenance and general provisions fairly quickly. First, we know that when we buy the license, we have the warranty. We may get a version of the software, for example, 1.0. During the period of setting up the software and implementing it, there may be patches and fixes that come out during that warranty period, even after productive use. And so, for example, we might get to release 1.0.1. In the maintenance and support arena, we have 2 different things in play. First are product entitlements, and second are support services. And that's what we're paying maintenance and support. That's why we're paying maintenance and support. So again, we get fixes and patches, and we may have to go to release 1.0.2 for additional new fixes and patches. We may even have an update that goes from release 1.0.2 to 1.1, or we may have a whole new version of the software that takes us from 1.1 to 2.0. The point here is you need to be very, very clear in your maintenance and support agreements as to which product entitlements you will receive. Not every maintenance and support agreement allows you to get new versions like the 2.0. Software companies will almost always ask you to pay more money when they go to a new release. So you need to be very clear about that. On the support side, you just need to make sure that you know that someone's going to answer the phone when you call 1-800-HELP-ME, and that it's somebody who knows the software and can help you with your problem, and that you have a service level agreement in place, an SLA, that holds them accountable to a standard for responding to your problem and providing you with a fix to the problem. That's essentially what this slide says, that there's a help desk usually internal to your organization. If they can't fix it, it escalates to level 2 to a product expert, usually outside of your organization. And ultimately, if they can't fix it, it may go to the development team at the publisher to fix severe issues. This is a quick example of an SLA, very, very simple, for the response time and the time to create a fix for issues based on a severity level. You and the vendor will agree what constitutes low, medium, and high severity, and what are the standards of response. How fast will you acknowledge that you have the problem in your court and that you're working on it, and how fast will you fix it? That is totally negotiable. These are just simple examples on this slide. The other thing is, when does the maintenance start? Similar to the question of when does warranty start? A lot of people are upset that they have to pay for maintenance at the same time the warranty is in place. They really serve 2 different purposes, although there is a lot of overlap. With maintenance, you're getting product enhancements potentially, as well as fixes to bugs and defects. So you probably want the maintenance to start concurrent with the warranty at the time you receive or start using the product. But you may say, look, I want the initial period of maintenance to go for a longer period than is usually offered out of the box, which is almost always 12 months. So you may want to ask for 18 months or even more when you start that maintenance. Now we're down to the 5th area, general provisions, which in the law are usually called boilerplate terms and conditions in a contract because they usually don't change very much. And people doing contracts don't want to change them very much. They're hard and fast. I give you a word of caution, however. My experience is that the commercial language and the commercial terms are very different usually in this particular area versus what is available to you in FAR and DFAR backed up by federal law. I'm just going to touch on 2 or 3 of these to give you a flavor for what I mean by that. Order of precedence. That is a clause in a contract that says if there are contradicting terms among documents or among clauses in an agreement, how do we resolve the conflict? What takes precedence or priority over other clauses? In the commercial world, it's negotiated extensively. As you probably know, in your world, it's in 52212-4S, and there's a list of the things that have priority in determining conflicts in a contract. Termination. Again, in the commercial world, extensive negotiation to figure out what constitutes grounds for termination and what are the rights of the parties if it happens. You have 52.212-4 L&M that gives you the right to terminate for cause or convenience. And if a termination for cause fails of its purpose, then it's just a termination for convenience. The impact on the vendor is different, we all know, but you have that exclusive right. You don't have to worry about it too much. Two more real quick: governing law and dispute resolution. They kind of go hand in hand. Most commercial agreements will say that any disputes will be litigated in the state where the vendor is headquartered using that state's laws. In the federal world, that's not the case. In the federal world, it's going to be federal law in federal court. And in fact, you resort first to the dispute resolution mechanism in 52.212-4D and the Dispute Act of 1948, I think it is, that's backed up by the process in 52.233-1. The contracting officer has the right to adjudicate these controversies. And one of the biggest things, and then if it goes to court, it goes to federal court with federal law. One of the biggest powers the contracting officer has, as you know, is that the vendor is held accountable for performance pending the outcome of a dispute. This is especially powerful in the world we're in today with cloud and SaaS, where you're at the mercy of the vendor. They may cut you off at their will. At least if you tell them in the contract and they know they're violating the contract, you can beat them up pretty badly afterwards. So make sure they understand that they have to perform pending the outcome of a dispute.
So what we find is that vendors will present their end-user license agreement first, and we say through ESI, we want to propose our own end-user license agreement, our master license agreement, terms and conditions. And through that process, you end up with a negotiated agreement that ideally will address our best practices, and yet will still satisfy the needs of the software publisher. It's very critical that whatever is negotiated be documented and, as we say, would be signed by both parties, software publisher, corporate official, as well as the contracting officer. It's going to be a very protracted conversation, though, in our experience, trying to hammer out those terms and conditions.
I told you a little while ago that we had a better slide to depict what cloud and SaaS looks like. This is it. On the far left is the traditional on-premise view of the infrastructure and all the things that it takes to operate an application. And it ranges all the way across to the right where we have software as a service. The green part is what you have control and management of. The blue part is what you're turning over to a third party. So you can see the four stacks are the same. They have all the same stuff in them: networking, storage, et cetera. And as you go to the right, more of it goes outside to the third party. I'm being given the sign that we have to conclude. I apologize. There's only a couple more slides. Key cloud SaaS, license considerations, SLAs, upgrades, customizations. Upgrades and customizations are at the whim of the vendor. You have little to no control of them in your world if you go outside with cloud or SaaS. And some licenses claim to be SaaS, but they're not really. Beware of that. We've seen vendors who say you have to download stuff on your client, on your laptop or what have you, and they're able to get into your systems to monitor what you're doing. You don't want to go there. SLAs are also critical for SaaS and cloud because one of the key things is the system going to be available to me when I need to use it? And there are all kinds of ways to calculate system availability. This is a quick example. We can run through the math some other time, but this is an example of 3 nines, 99.9% availability, which equates generally to about 2 hours of unplanned downtime over a 90-day period. So you have to figure out, what do I really need in my environment? Do I need a high level of availability because it's a super mission critical application, or can I get away with less? Because the more you ask for, the more it's going to cost.
So one last thought. We are doing extensive training, offering training through DoD ESI. The Ask an Expert feature on our webpage will get you the ability to register for training. We're doing a lot of training of contracting officers right now. Two-day workshops a month around the country. We also have online tutorials on over 30 topics, a lot of which were touched on today, that are accessible through our website. We also have monthly webinars on end-user license agreements, as well as software license management, or IT asset management. Our content is accessible through the acquisition gateway, the software category hallway, or directly by just going to www.esi.mil, and you'll find all of our white papers, toolkits, and training presentations there. Thank you.
Thanks.